Good day, sir. We are the group 4 to present the pages 36 to 47 for Labor Code of the Philippines. For the first topic, the Article 194 that simplify this particular topic, payment to primary beneficiaries, monthly income of the deceased benefit plus 10% for each dependent child, but it must be only up to 5. And it is guaranteed for 5 years. Minimum death benefit not less than 15,000 pesos. Payment to secondary beneficiaries if no primary beneficiary. For the funeral benefit, it is 3,000 pesos. Next is Article 195, Relationship and Dependency. All questions of relationship and dependency shall be determined as of the time of death. And then next, Article 196, Delinquent Contributions. An employer who is delinquent in his contributions shall be liable to the system for the benefit which may have been paid by the system to his employees or their dependents. Failure or refusal of the employer to pay or remit the contribution herein prescribed shall not prejudice the right of the employee or his dependents to the benefits under his title. Next is Article 197, Second Injuries. If any employee under permanent partial disability suffers another injury which results in a compensable disability greater than the previous injury, the state insurance fund shall be liable for the income benefits of the new disability, provided that if the new disability is related to the previous disability, the system shall be liable only for the difference in income benefits. Next is Article 198, Assignment of Benefits. No claim for compensation under this title is transferable or liable to tax, attachment, garnishment, levy, or seizure by or under any legal process whatsoever, either before or after receipt by the person or persons entitled thereto, except to pay any debt of the employee to the system. For Article 199, Earned Benefits. Income benefit shall, with respect to any period of disability, be payable in accordance with this title to an employee who is entitled to receive wages, salaries, or allowances for holidays, vacation or sick leaves, and any other award of benefits under a collective bargaining or other agreement. For Article 200, Safety Devices. In case of employee's injury or death was due to the failure of employer to comply with any law or to install and maintain safety devices or to take other precautions for prevention of injury, said employer shall pay the state insurance fund a penalty of 25% of the lump sum equivalent of the income benefit payable by the system to the employee. Next is Article 201. Prescriptive period. No claim for compensation shall be given to course unless said claim is filed with the system within 3 years from the time the cause of action accrued. Then Article 202. Erroneous payment. If system in good faith pays income benefit to a dependent who is inferior in the right to another dependent, or with whom another dependent is entitled to share, such payment shall discharge the system from liability unless and until such other dependent notifies the system of his claim prior to the payments. For Article 203, prohibition. No agent, attorney, or other person pursuing or in charge of the preparation or filing of any claim for benefit under this title shall demand or charge for his service any fee, and any stipulation to the contrary shall be null and void. The retention or deduction of any amount from any benefit granted under this title. Article 204, exemption from levy, tax, etc. All laws to the contrary, notwithstanding, the state insurance fund and all its assets shall be exempt from any tax, fee, charge, levy, or customs or important duty, and no law hereafter enacted shall apply to the state insurance fund unless it is provided therein that the same is applicable by expressly stating its name. For Chapter 9, Records, Reports, and Penal Provisions, Article 205, Record of Death or Disability. All employers shall keep a logbook to record chronologically the sickness, injury, or death of their employees. All entries in the employer's logbook shall be made by the employer or any of his authorized official after verification of the contingencies. Should any employer fail to record in the logbook an actual sickness, injury, or death of any of his employees within the period prescribed herein, give false information or withhold material information already in his possession. In case of payment of benefits for any claim which is later determined to be fraudulent and the employer is found to be a party to the fraud, such employer shall reimburse the system the full amount of the compensation paid. Next is Article 206, Notice of Sickness, Injury, or Death. Notice of sickness, injury, or death shall be given to the employer by the employee or by his dependents or anybody on his behalf within 5 days from the occurrence of the contingency. No notice to the employer shall be required if the contingency is known to the employer or his agents or representatives. Article 207, Penal Prohibitions. The penal prohibitions of Republic Act numbered 1161 as amended and Commonwealth Act numbered 186 as amended with regard to the funds as the funds are thereunder being paid to, collected or disbursed by the system will be applicable to the collection, administration, and disbursement of the funds under this title. The penal prohibitions on coverage shall also be applicable. For Article 208, applicability. This title shall apply only to injury, sickness, disability, or death occurring on or after January 1975. Article 208A, repeal. All existing laws, presidential decrees, and letters of instructions which are inconsistent with or contrary to the decree are hereby repealed, provided that in the case of the GSIS, condition for entitlement to the benefit shall be governed by the Labor Code. Title 3, Medicare, under Article 209, Medical Care. The Philippine Medical Care Plan shall be implemented as provided under Republic Act numbered 6111 as amended. Right? For adult education. Article number 210, adult education. Every employer shall render assistance in the establishment and operation of adult education programs for their workers and employees as prescribed by regulations jointly approved by the Department of Labor and Employment and the Department of Education, Culture and Sports. Book 5, Labor Relations. Title 1, Policy and Definitions. Chapter 1, Policy. Article 211, Declaration of Policy. It is the policy eh, the policy of the state is to promote and emphasize the primacy of free collective bargaining and negotiations, including voluntary arbitration, mediation, and conciliation as modes of setting labor or industrial disputes. To promote free trade, unionism as an instrument for the enhancement of democracy and the promotion of social justice and development. To foster the free and voluntary organization of a strong and united labor movement. To promote the enlightenment of workers concerning their rights and obligations as union members and as employees. To provide an adequate administrative machinery for the expeditious settlement of labor or industrial disputes. To ensure a stable but dynamic and just industrial peace, and to ensure the participation of workers and decision and policy making process affecting their rights, duties, and welfare. Chapter 3, Definitions, Article 212, Definitions. Francis.
Chapter 2 Definitions, Art 212 Definitions. A. Commission means the National Labor Relations Commission or any of its divisions, as the case may be, as provided under this code. Next. Next is B. Bureau. Means the Bureau of Labor Relations and or the Labor Relations Divisions in the regional offices established under Presidential Decree number 1 in the Department of Labor. Next. C. Board. Means the National Conciliation and Mediation Board established under Executive Order number 126. Next is D. Council. Means the tripartite, voluntary arbitration advisory council established under Executive Order number 126 as amended. Next. E. Employer. Includes any person acting in the interest of an employer, directly or indirectly. The term shall not include any labor organization or any of its officers or agents except when acting as employer. Next. F. Employee. Includes any person in the employ of an employer. The term shall not be limited to the employees of a particular employer unless the code is explicitly states. It shall include any individual whose work has ceased as a result of or in connection with any current labor dispute or because of any unfair labor practice if he has not obtained any other substantially equivalent and regular employment. Next. G. Labor organization means any union or association of employees which exists in whole or in a part for the purpose of collective bargaining or of dealing with employers concerning terms and conditions of employment. Next. H. Legitimate labor organization means Any labor organization duly registered with the Department of Labor and Employment and includes any branch of local thereof. Next, I. Company union means any labor organization whose formation, function, or administration has been assisted by any act defined as unfair labor practice by this code. Next, bargaining. Bargaining representative means a legitimate labor organization whether or not employed by the employer. Next, unfair labor practice means any unfair labor practice as expressly defined by the code. Next, labor dispute includes any controversy or matter concerning terms and conditions of employment or the association or representation of persons in negotiating, fixing, maintaining, changing, or arranging the terms and conditions of employment, regardless of whether the disputants stand in the approximate relation of employer and employee. Next, M. Managerial employee is one who is vested with the powers or prerogatives to lay down and execute management policies and or to hire, transfer, suspend, lay off, recall, discharge, assigned, or discipline employees. Supervisory employees are those who, in the interest of the employer, effectively recommend such managerial actions if the exercise of such authority is not merely routinary or clerical in nature but requires the use of independent judgment. Next, all employees not falling within any of the above definitions are considered rank and file employees for purposes of this book. Next, N. Voluntary arbitrator means any person accredited by the board as or any person named or designated in a collective bargaining agreement by the parties to act as the voluntary arbitrator, or one chosen with or without the assistance of the National Conciliation and Mediation Board pursuant to a selection procedure agreed upon the collective bargaining agreement, or any official that may be authorized by the Secretary of Labor and Employment to as voluntary arbitrator upon the written request and agreement of the parties to a labor dispute. Next, strike means any temporary stoppage of work by the concerted action of employees as a result of an industrial or labor dispute. Next is lockout means any temporary refusal of an employer to furnish work as a result of industrial or labor dispute. Next, internal union dispute includes all disputes or grievances arising from any violation of or disagreement over the provision of the Constitution and by laws of a union, including any violation of the rights and conditions of union membership provided for in this code. Next, S. Strike area means the establishment where warehouses, depots, plants or offices including the sites or premises used as runway shops of the employer struck against, as well as the immediate vicinity actually used by picketing strikers in moving to and from before all points of entrance to and exit from said establishment. Next,
Next. Title 2, National Labor Relations Commission. Next. Article 213
there shall be a National Labor Relation Commission which shall be attached to the Department of Labor and Employment for program and policy coordination only, composed of chairman and 14 members. Next. Article 214, Headquarters, Branches and Provincial Execution Units. The Commission and its first, second, and third division shall have their main offices in Metropolitan Manila, and the fourth and fifth division in the cities of Cebu and Cagayan de Oro, respectively. Next. Article 215, Appointment and Qualification. The President will choose commission from the list of the nominees presented by the exclusive representatives certified and compliance with the code rules. Article 216, Salaries, Benefits, and Other Emoluments. The NLRC Executive Labor Arbitrator, Commissioner, Chairman, Labor Arbiters, and other staff members. Paid benefits and other emoluments are set forth in this article. Next. Article 217, Jurisdiction of the Labor Arbiters and the Commissioner. 1. Unfair labor practice cases. 2. Termination disputes. 3. If accompanied with a claim for reinstatement, those cases that works may file involving wage, rates of pay, hours of work, and other terms and conditions of employment. Next. Article 217, number 4, claims for actual, moral, exemplary, and other forms of damage arising from the employer-employees relations. 5. Case arising from any violation of Article 264 of this code, including questions involving the legality of strike and lockouts. Next. Number 6. Expect claims of employees, compensation, social security, Medicare, and maternity benefits, all other claims arising from employee-employee relations, including those of person in domestic or household service involving an amount exceeding 5,000 pesos, regardless of whether accompanied with a claim for reinstatement. Next. Article 218, Powers of the Commission is given broad authority under Article 218 to settle labor disputes, advance ethical workplace conduct, and protect the rights and interests of employers and employees in the Philippines. Article 219, Ocular Inspection. Article 219 gives the Secretary of Labor and his or her authorized representative the authority to visual examine workplace. Article 220, Compulsory Arbitration. Institution where negotiation is unsuccessful or where the disagreement impacts industry that are vital to the country's interest. Article 221, Technical rules not binding and prior resort to amicable settlement. In order to foster collaboration, comprehension, and efficiency in resolving dispute between employers and employees. Next. Article 222. In order to guarantee the parties have access to legal advice and that attorney costs are fair and governed. Article 222 lays out the requirements for representation by counsel in labor proceeding as well as the guidelines for attorney fees. Next. Article 223, decision awards or orders of the labor arbiter are final the executory unless appealed to the commission by any both parties within 10 calendar days from receipt of such decision. Award or orders, such appeal may be entertained only any of the following grounds. Next. B. If the decision, order, or award was secured through fraud or fabrication, including graft and corporation. C. If made purely on question of law. Next. D. If serious errors in the findings of facts are raised which would cause grave or irreparable damage or injury to the applicant. Article 224, execution of decision, orders, or awards. In order to ensure compliance with the labor laws and to promote the finality and efficiency of the NRRCs or its labor arbiters, rulings in settings labor disputes. Article 225, contempt powers of the Secretary of Labor. Article 225 gives the Secretary of Labor and Employment the power to punish those who disobeyed or obstruct the orders, resolution, or decision issued under their purview with contempt in order enforce compliance with labor laws and the regulation.
Title 3, Bureau of Labor Relations. Article 226, Bureau of Labor Relations and the Labor Relations Divisions in the regional offices of the Department of Labor shall have original and exclusive authority to act at their own initiative or upon request of either or both parties on all inter-union and intra-union conflicts and all disputes, grievances or problems arising from or affecting labor management relations in all workplaces, whether agricultural or non-agricultural, except those arising from the implementation or interpretation of collective bargaining agreements, which shall be the subject of grievance procedure and or voluntary arbitration. Article 227, compromise agreements. Any compromise settlement, including those involving labor standard laws, voluntarily agreed upon by the parties with the assistance of the Bureau or the regional office of the Department of Labor, shall be final and binding upon the parties. The National Labor Relations Commissions or any court shall not assume jurisdiction or over issues involved therein except in case of non-compliance thereof, or if there is prima facie evidence that the settlement was obtained through fraud, misrepresentation, or correction. Next is Article 228, endorsement of cases to labor arbiters. Letter A, except as provided in paragraph of this article, the labor arbiter shall entertain only cases endorsed to him for compulsory arbitration by the Bureau or by the regional director with a written notice of such endorsement or non-endorsement. The endorsement or non-endorsement of the regional director may be appealed to the Bureau within 10 working days from receipt of the notice. Letter B, the parties may, at any time by mutual agreement, withdraw a case from the conciliation section and jointly submit it to a labor arbiter, except deadlocks in collective bargaining. Next is Article 229, issuance of subpoenas. The Bureau shall have the power to require the appearance of any person or the production of any paper, document or matter relevant to a labor dispute under its jurisdiction, either at the request of any interested party at its own initiative. Next is Article 230, Appointment of Bureau Personnel. The Secretary of Labor and Employment may appoint, in addition to the present personnel of the Bureau and the Industrial Relations Divisions, such number of examiners and other assistants as may be necessary to carry out the purpose of the code. Next is Article 231, the Registry of Unions and File of Collective Bargaining Agreements. The Bureau shall keep a registry of legitimate labor organizations. The Bureau shall also maintain a file of all collective bargaining agreements and other related agreements and records of settlement of labor disputes and copies of orders and decisions of voluntary arbitrators. Next is Article 232, Prohibition on Certification Election. The Bureau shall not entertain any petition for certification election or any other action which may disturb the administration of duly registered existing collective bargaining agreements affecting the parties except under Articles 253, 253A, and 256 of this code. Next is Article 233, Privilege Communication. Information and statements made at conciliation proceedings shall be treated as privileged communication and shall not be used as evidence in the commission. Conciliators and similar officials shall not testify in any court or body regarding any matters taken up at conciliation proceedings conducted by them. Title 4, Labor Organizations. Chapter 1, Registration and Cancellation. Article 234, Requirements of Registration. Any applicant, labor organization, association, or group of unions or workers shall acquire legal personality and shall be entitled to the rights and privileges granted by law to legitimate labor organizations upon issuance of the certificate of registration based on the following requirements. Letter A, 50 pesos registration fee. Next is the names of its officers, their addresses, the principal's address of the labor organization, the minutes of the organizational meetings, and the list of the workers who participated in such meetings. Next is the names of all its members or comprising at least 20% of all the employees in the bargaining unit where it seeks to operate. Next is if the applicant union has been in existence for 1 or more years, copies of its annual financial reports, the names of all its members comprising at least 20% of all the employees in the bargaining in the bargaining unit where it seeks to operate. Next is 4 copies of the Constitution and bylaws of the applicant union, minutes of its adoption or ratification, and the list of the members who participated in it. Next is Article 235, Action on Application. The Bureau shall act on all applicants for registration within 30 days from filing. Article 236, Denial Registration Appeal. The decision of the Labor Relations Division in the regional office denying registration may be appealed by the applicant union of the Bureau within 10 days from receipt of notice thereof. Next is Article 237, Additional Requirements for Federation or National Unions. Subject to 238, if the applicant for registration is a federation or a national union, It shall, in addition to the requirements of the preceding article, submit the following: proof of the affiliation of at least 10 locals or chapters, each of which must be a duly recognized collective bargaining agent in the establishment or industry in which it operates, supporting the registration of such applicant, federation or national union, and the names and addresses of the companies where the locals or chapters operate, and the list of all the members in each company involved. Next is Article 238, conditions for registrations of federation or national unions. No federation or national union shall be registered to engage in any organization activity in more than one industry in any area or region, and no federation or national union shall be registered to engage in any organizational activity in more than one industry all over the country. The federation or national union which meets the requirements and conditions herein prescribed may organize and affiliate locals and chapters without registering such locals or chapters within the Bureau. That's all. Thank you.